Chapter 6. It contains process to compel appearances. These are given under section 61 to section 90 of Criminal Procedure Code. Chapter 6 is divided into 4 parts to compel appearance of a party to the court. Number 1, A. Summons. Number 2, B. Warrants of arrest. Number 3, C. Proclamation and attachment. And number 4, D. Other rules regarding processes. This chapter has 30 sections, and we all face a common problem that we are not able to learn all the sections as per the bare acts. So in this lecture we are using some tricks, and even the colors are used so that we can correlate them and learn each sections by heart. Just play this video a couple of times and I assure you, you will learn this chapter by heart. As we have already covered that the process to compel appearances in chapter 6 is divided into 4 parts. Now let's proceed further that the first part, summons. Summons is less serious in nature, so I have shown it in green. The provisions are under section 61 to section 69 and it has 9 sections in total. The second one, warrant of arrest, definitely it is serious in nature, so I have shown it in red color, and the provisions are given under section 70 to 81, 12 sections in total. The other one, proclamation and attachment, relates to the movable and immovable property of yours, and it's shown in yellow color. Provisions are contained in section 82 to 86 and it has total 5 sections. And the last one, other rules regarding the processes, and it's given in blue color, and the provisions are under section 87 to 90. The smallest one, only 4 sections are given. Never be afraid of committing mistakes. Mistakes are proof that you are trying. And success is achieved only if you try. I have been loaded with requests that they do not understand Hindi. And on the other hand, I have been loaded with such requests also that they do not understand English. So here we have a solution. This lecture is completely in English, and the same lecture is also available in Hindi. Students, advocates, and other legal professionals, please join me on Telegram group, and it's a very disciplined group, and the link is given below. WhatsApp group was available before, but it has been removed because of 2 reasons. One, it does not support more than 256, and it shows the mobile phone numbers of all the members. So definitely privacy is the top priority for me as well, and in Telegram, your number is not displayed if I'm not wrong. So, without afraid, join me on Telegram. The link is given below. Just download the Telegram app and then click on the link given below. This legal group is making a habit of learning one legal word every day. And even I will be learning so many things from so many new people. Now, before we start this lecture, let me inform you that this lecture is totally based upon Bare Act of Criminal Procedure Code 1973. Now let's come to the point how to attempt this question in any examination. Let's begin with introduction. To meet the ends of justice, it is critical to produce the accused and other witnesses or related parties before the court whenever needed. If the accused is found guilty at the conclusion of the trial, he must be present in person to receive the sentence. Also, his presence is necessary if imprisonment is to be enforced. For this reason, Chapter 6, Section 61 to Section 90 of Criminal Procedure Code provide four ways for compelling the appearances of a person who is required to be present in the court. What are these four ways? The first one, summon, section 61 to 69. Second one, warrant of arrest, section 70 to 81. Third one, proclamation and attachment, section 82 to section 86. And the fourth one, other rules regarding processes given under section 87 to section 91 of Criminal Procedure Code. Tricks to learn this in serial order. Saturday with police officer. S for summons, W for warrant of arrest, and P for proclamation and attachment, and O for others. नहीं पसंद आया. Okay, you did not like it. Let's change this trick then. Simply weird person out. I think you will like this one now. S for summons, W for warrant of arrest, P for proclamation and attachment, O for other rules regarding the processes. Now let me try to attempt a trick to learn all these sections. 6, 7, double it. You didn't get it, right? Even I didn't get it properly. But if we write this in front of simply weird person out, I think it makes some sense. 6, 7, double it. And if we add on 1027, now you can see that it makes sense. 61, the summon begin with. 70, the warrant of arrest begin with. Proclamation of attachment begins with 82. And other rules regarding processes begins with 87. Now we start in reverse order. We already know that the chapter 6 is process to compel appearances begins with section 61 and ends with section 91. So if we start from reverse order, section 91 is the last one we write over here, then automatically 87 is the beginning of other processes. This means the previous one ended with section 86. And we see over here that if proclamation is starting at section 82, which means that the previous one ended at section 81. And again we see that if warrant of arrest starts with section 70, which means that the previous one ended with section 69. Now it makes sense. The first part, summons 61 to 69. The second part, warrant of arrest, section 70 to 81. Proclamation of attachment, section 82 to 86. And other rules regarding processes, section 87 to section 91. Most of you must be getting bored that why we are reading it again and again. Man, this is how we learn jingles, advertisements. When we watch television, they are showing us the advertisement again and again and again, and we are forced to learn their jingles. Same trick is applied over here. We play this again and again and again. We might be getting really bored, but unknowingly, you will remember it by heart. Process to compel appearances. First part, summons. Let's cover summons as given under the provisions of section 61 to section 69. They are total 9 sections. Summons. The first part, summons, says that forms of summons given under section 61, forms are shown in scheduled 2, form number 1 and form number 30. They are really helpful and make you understand summons in a better manner. Summon is milder form of processes. Summons are issued A for enforcing the appearances of the accused or of witness. This is for both the accused and the witnesses. And B for production of a document or a thing. The accused or witness may be asked, may be given someone to come and appear in the court, either to produce a document or a thing or to give a statement. Summon case relates to less serious offences, and as per the provision of section 61 of Cr.PC 1973 provides that every summon issued by a court must be in writing, in duplicate, and signed by the presiding officer of the court. It must also bear the court seal. This is a very important part. So never forget this important part regarding summons. Uh, it must be in writing. Section 61 says that summon must be written. It must be in duplicate. Definitely, that's why how you take one summon and receiving is taken on the other one. One you give to the person who is being summoned to the court. The notice of summon is given in duplicate. Third important factor, summons under section 61 is to be signed by the presiding officer of the court issuing it. So it must have the signature of the officer of the court issuing it to compel a person to appear before a court. And the most important part, it must be sealed. Without the seal, one cannot know which court has issued these summons. So, seal is a very important part. Any one of this is missing, then summons are improper and not valid. Now, let's take up a case of Emperor versus Rananjay Singh. This is a case of 1928. A summon must clearly show the name and address of the person summoned, the place, date, and time at which the person summoned is to attend, and place, date, and nature of the offense committed if there is an offense committed. In absence of such particulars, the proceedings taken thereon are invalid and can be objected by the person summoned. Second part of the summons, section 62, summons how served. or mode of service of summons. Subsection 1 of Section 62 says that every summons shall be served by a police officer of the state, or the state government may make rule in this regard. Everybody knows that summons are issued by the police officer, but lawyer, law students know this thing, that summons served by police officers are under Section 62, subsection 1. Means subsection 1 of Section 62 of Criminal Procedure Code provides that the summons shall be issued by a police officer, or as the state government may make rule. Subsection 2 says this thing, that the summons shall, if practicable, be served personally on the person summoned by delivering or tendering him one of the duplicates of the summons. Subsection 3 says every person on whom summons is so served shall, if so required by the serving officer, sign a receipt thereof on the back of the other duplicate. So here we have covered the second part of the summons. Third point of summons, service of summons on corporate bodies or the societies. Section 63 provides that service of summons on a corporate may be effected by serving it on the secretary, local manager, or principal officer of the corporation, or by letter sent by registered post addressed to the chief officer of the corporation in India. The explanation to Section 63 says that in this section, corporation means an incorporated company or other bodies, corporate, and includes a society registered under Societies Registration Act 1860. So, corporation under this section includes a society. Fourth part of summons, service when person summoned cannot be found. Section 64 says where the person summoned cannot, by exercise of due diligence, be found, the summons may be served by leaving one of the duplicates for them with some adult male member of the family residing with him. And the person with whom the summons is so left shall, if so required by serving officer, signed a receipt thereof on the back of the other duplicate as it's been served to the original one. This means that no, the servant or the cook of the house not allowed. They are not to be considered as family members. Fifth part, procedure when service cannot be effected as before, as given under the provisions of Section 65. If the service cannot, by the exercise of due diligence, be effected as provided under Section 62, 3 and 4, the serving officer shall affix one of the duplicates of the summons to some conspicuous part of the house or house stead in which the person summoned ordinarily resides, and thereupon the court, after making such inquiries as it think fits, may either declare that the summon has been duly served, or order fresh services in such manner as it considers proper. So, under the topic summons, 61 says about the form of summons, and 62, 63, and 64 says how the summons are to be served. 65 is the part where it is said that if the person is not available, or when we are not able to serve the summon, even as under given as under Section 64, that it could be given to any other male member of the family, even if that's not possible, then the provisions of 65 says that in such cases the summon should be affixed, pasted on some conspicuous part of the house, means part of the house which is visibly clear to the visitor or to the person to whom the summon has been issued. Whenever he comes and visit to his house, he can see that, oh, someone has pasted something and that is summon, and he can visit the court accordingly. Sixth part of summons: services on government servant as per the provisions of section 66. Subsection 1 of section 66 says, where the person summoned is in active service of the government, the court issuing the summons shall ordinarily send it in duplicate to the head of the office in which the such person is employed, and such head shall thereupon cause the summon to be served in the manner provided by section 62 and shall return it to the court under his signature with endorsement required by that section. Basically, subsection 1 of section 60 says that if a someone is to be served to a government employee and a person who is working in a government department, the court shall send the summon to the head of the department so that they can serve it accordingly. um yes, head of government department if person is in government job under section 66 subsection 1. Everybody needs to remember that. Thank you. Now we come to the next point, seventh point of summons, which says that service of summons outside local limits as per the provisions of section 67. Section 67 says that when a court desires that the summon issued by it shall be served at any place outside its local jurisdiction, it shall ordinarily send such summons in duplicate to a magistrate within whose local jurisdiction the person summoned resides or is to be there served. So, section 67 basically says that if a local magistrate is issuing a summon to a person who is outside the jurisdiction of his court, then the court shall send the summon to the court in whose jurisdiction that person resides. I hope it's very easy concept, and just go through it. You will learn it by heart. We come to the eighth point of summon: proof of service in such cases and when serving officer is not present. It is given as per the provisions of section 68. Subsection 1 of section 68 says, when summons is issued by a court is served outside its local jurisdiction, and in any case where the officer who has served a summons is not present at the hearing of the case, an affidavit purporting to be made before a magistrate that such summon has been served, and a duplicate of the summon purporting to be endorsed in a manner provided under section 62 or section 64 as it is explained before by the person to whom it is delivered to be tendered or with whom it was left shall be admissible in evidence, and that the statements made therein shall be deemed to be correct unless and until the contrary is proved. So basically, what subsection 1 of section 68 says that the summons has been served can be proved by presenting the duplicate copy of the summons in the court until and unless the contrary is proved. Next, subsection 2 of section 68 says that the affidavit mentioned in this section may be attached to the duplicate of the summons and returned to the court. Now we come to the last point, ninth point of summons. Section 69 says that service of summons on witnesses by post. Something interesting. Subsection 1 of section 69 says, notwithstanding anything contained in the preceding sections of this chapter, A court issuing a summon to a witness may, in addition to or simultaneously with the issue of such summons, may direct a copy of summon to be served by registered post addressed to the witness at the place where he ordinarily resides or carries on business or personally works for gain. Basically, what you have to remember is subsection 1 of section 69 deals with summon to witnesses, and that also can be sent by registered post. Subsection 2 of section 69 says when an acknowledgement purporting to be signed by the witnesses or an endorsement purporting to be made by a postal employee that the witnesses refuse to take a delivery of the summons has been received, the court issuing the summons may declare that the summons has been duly served. Okay, this is a very interesting fact that whenever a service of summon is done on a witness, they try to avoid it. They do not want to visit courts. And when the service of summon is done by post, they refuse to accept it. So when a witness refuses to accept such a summon of the court, the postman, the person who has visited the house, place of work, or wherever his business is working for gain, the postman will give a remarks on the envelope of the summons that he or she has refused to take the delivery of the summon, and the same will be presented to the court. When it is presented to the court will presume and declare that the summon has been duly served. So all the advocates out there are requested that advise your client to take the summons. Do not avoid it until and unless you really want them to avoid to earn some more time. Now we come to the second part of the chapter 6, process to compel appearances, that is warrant of arrest. Under the provisions of section 70 to section 81, total 12 sections. First part of warrant is the form of warrants of arrest and its duration as per the provisions of section 70 of the CRPC. So before I start this topic, do you remember that the topic summons also started with the forms, and it was as per the provision of section 61. I'm repeating this so that you can recall it, that summons started with section 61 and it ended in 69, and warrant started with 70 and it's going to end with section 81. Now let's cover the topic warrant. The first point, form of warrant of arrest and its duration as per the section 70. Subsection 1 of 70 says that every warrant of arrest issued by the court under this code shall be in writing, signed by the presiding officer of such court, and shall bear the seal of the court. Do you remember that it has the same contents as the contents of the summons? Even a layman knows that the warrant of arrest is presented by the police officer. But a student of law, advocate, any law literate person knows this thing, that warrant of arrest is issued under subsection 1 of section 70 of Criminal Procedure Code. Next, subsection 2 of 70, it says that every such warrant shall remain in force until it is cancelled by the court which issued it, or until it is executed. So subsection 1 of section 70 says regarding the form of the warrant of arrest and its duration, and subsection 2 of section 70 says that it will continue to remain in force until it is either cancelled by the court or it has been executed. Executed means obviously the person has been arrested. Second point of warrant of arrest is power to direct security to be taken, and it is given as per the provision of section 71 of the Criminal Procedure Code. Subsection 1 of section 71 says this thing, that any court issuing a warrant for the arrest of a person may in its discretion means the judicial officer has to apply his mind whether not to do so, direct by endorsement on the warrant that if such person executes a bond with sufficient sureties for his attendance before the court at the specified time and thereafter, until otherwise directed by the court, the officer to whom the warrant is directed shall take such security and shall release such person from custody. So basically, subsection 1 of section 71 says this thing, that when a warrant of arrest is issued by the judicial officer, the court may, in the same warrant, may give directions that if the person so to be arrested is ready to give some bond and sufficient sureties for his attendance before the court at a specified time whenever the court has asked for, the officer to whom the warrant is directed shall take such security. Means if a police officer say for example an SHO is directed to serve the warrant of arrest, he can release the person from custody after taking the securities that the court has asked for, if the person is ready to give such securities for his presence in the court. Subsection 2 of section 71 says this thing, the endorsement shall state. Now, it is talking about the endorsement with the warrant of arrest. There are 3 points. A, the number of sureties to be taken. B, the amount in which they and the person for whom arrest the warrant is issued are to be respectively bound. 3, the time at which he is to attend before the court. Third part of section 71, that is subsection 3 of section 71, says this thing, whenever security is taken under this section, the officer to whom the warrant is directed shall forward the bond to the court. This means that the police officer is not going to keep the bond with himself. He is going to present it in the court that we have already taken such bond from him and he need not be arrested. The important thing to learn in this subsection 71 is number of sureties. It may be 1, 2, 3 as the court may has directed to. Second thing, the amount that is specified in the warrant. And the third and the last and the most important, time at which he has to attend before the court. So whenever warrant of arrest come to your mind, it should remind you about section 71, and section 71 must remind you sureties, amount and time. Third point of warrant of arrest. Warrant to whom directed. Section 72. Subsection 1 of section 72 says this thing, a warrant of arrest shall ordinarily be directed to one or more police officers. But the court issuing such a warrant may, if its immediate execution is necessary and no police officer is immediately available, direct it to any person or persons, and such person or persons shall execute the same. So, subsection 1 of section 72 basically tries to explain that the police officer will serve the warrant of arrest, and if the court think that police is not immediately available and the execution of arrest warrant is necessary, then the court may direct anyone to execute the same. Subsection 2 of section 72 says that when a warrant is directed to more persons, officers than one, it may be executed by all or by any one or more than one. So the confusion may be removed that if a warrant is given to more than one person under subsection 1 of section 72, the answer is any one given under subsection 2 of section 72 of warrant of arrest. Warrant may be directed to any person as per the provision of section 73. Subsection 1 of 73 says this thing that the chief judicial magistrate or a magistrate first class may direct a warrant to any person within his local jurisdiction for the arrest of any escaped convict, proclaimed offender, we call them PO as well, or any person who is accused of a non bailable offense and is evading arrest. Subsection 2 of section 73 says this thing such person shall acknowledge in writing a receipt of the warrant and shall execute it if the person for whose arrest it was issued is in or enters on any land or other property under his charge. Subsection 3 of section 73 says this thing when the person against whom a warrant is issued is arrested, he shall be made over with the warrant to the nearest police officer who shall cause him to be taken before a judicial magistrate having jurisdiction in this case unless security is taken under section 71. Security is to be taken, we have already covered under section 71. Nothing much to cover in it. Section 73 says this thing that chief judicial magistrate or a magistrate of first class may direct any person which is under subsection 1 of 73, and the receipt has to be taken where you are entering a place or a land to arrest such person, that is given under subsection 2 of 73, and the last subsection 3 of 73 says this thing that if a person is arrested, he will be brought before the magistrate in his jurisdiction unless the security is already taken under section 71. Means the person need not to be arrested or brought before the magistrate because he has already given the security. If the provision of security was given under the warrant of arrest as per the discretion of the magistrate. Fifth point, warrant directed to police officer. The fourth point was warrant directed to any person as per the provision of section 73. Now the fifth point is warrant directed to police officer as per the provision of section 74. A warrant directed to any police officer may also be executed by any police officer whose name is endorsed upon the warrant by a police officer to whom it is directed or endorsed. Section 74 is trying to say this thing that a warrant of arrest, if it is directed to a police officer named ABC and he is required to execute it or serve it to the person to be arrested and he has to arrest it, it is not necessary that he will arrest it. The warrant of arrest having a name of ABC can be executed even by the other police officer named XYZ. Got it? That's good. Let's move to the next point. Point number 6 of warrant of arrest. Notification of substance of warrant as per the provision of section 75. Section 75 says this thing that the police officer or other person executing a warrant of arrest shall notify the substance thereof to the person to be arrested and if so required shall show him the warrant. So do not forget the substance of warrant is given under section 75, that is the contents of the warrant of arrest, as this question comes in judicial examination as well. Seventh point, person arrested to be brought before the court without delay as per the provision of section 76 of Criminal Procedure Code. Section 76 says that the police officer or other person executing a warrant of arrest shall, without unnecessary delay, bring the person arrested before the court before which he is required by law to produce such person, provided that the delay shall not in any case exceed 24 hours, exclusive of the time necessary for the journey from the place of arrest to the magistrate court. So, under section 76, do not forget two things. One, the person, if he is arrested, should be brought before 24 hours is passed. So, within 24 hours, he has to be brought before a magistrate on duty, and if it is after duty hours, and to the court if it is court hours, but within 24 hours. Next is where the warrant may be executed. Section 77 says this thing: a warrant of arrest may be executed at any place of India. Ninth point of warrant of arrest: warrant forwarded for execution outside jurisdiction as per the provision of section 78. This is the ninth point of the warrant of arrest. Subsection 1 of section 78 says this thing: when a warrant is to be executed outside the local jurisdiction of the court issuing it, such court may, instead of directing the warrant to the police officer within its jurisdiction, forward it by post or otherwise by any executive magistrate or district superintendent of police or commissioner of police within the local limits whose jurisdiction it is to be executed. And the executive magistrate or the district superintendent or commissioner shall endorse his name thereon, and if practicable cause it to be executed in manner therebefore provided. Subsection 1 of section 78 is trying to tell us that the warrant of arrest, if it is to be served outside the local jurisdiction of the court, it may, instead of giving it to the police officer of that area, may direct to the executive magistrate or a district superintendent of police or the commissioner of that area in which it has to be given. Next is subsection 2 of section 78. The court issuing the warrant under subsection 1, which I have already covered before this, shall forward along with the warrant the substance of information against the person to be arrested, together with such documents, if any, as may be sufficient to enable the court acting under section 81 to decide whether bail should or should not be granted to the person. 10th point of warrant of arrest: warrant directed to police officer for execution outside jurisdiction as per the provisions of section 79. Subsection 1 of section 79 says this thing: when a warrant directed to a police officer is to be executed beyond the local jurisdiction of the court issuing the same, he shall ordinarily take it for endorsement either to an executive magistrate or to a police officer not below the rank of a officer in rank of police station, within the local limits of whose jurisdiction the warrant is to be executed. So we already covered in section 78 that the court can execute a warrant outside the jurisdiction. Now in section 79, it is giving us the direction. It is giving the court the direction when a warrant is executed outside the jurisdiction and is directed to the police officer, it shall either endorse the same either to the executive magistrate or the police officer not below the rank of an officer in charge of a police station, within the local limits of whose jurisdiction the warrant is to be executed. Got my point? No? Replay it. Okay, next, subsection 2 of section 79. Such magistrate or a police officer shall endorse his name thereon, and such endorsement shall be sufficient authority to the police officer to whom the warrant is directed to execute the same, and the local police shall, if so required, assist such officer in executing such warrant. Next is subsection 3 of section 79. It says, whenever there is a reason to believe that the delay occasioned by obtaining the endorsement of the magistrate or police officer within whose local jurisdiction the warrant is to be executed will prevent such execution, the police officer to whom it is directed may execute the same without such endorsement in any place beyond the local jurisdiction of the court which issued it. Now, this section should not be complicated just because it says that he can, even without having the jurisdiction, can, beyond his jurisdiction, issue it. It is only in those circumstances where the magistrate or the police officer in whose jurisdiction the warrant is to be executed will prevent such execution. It is in exceptional circumstances. So, subsection 3 of section 79 of the Criminal Procedure Code is used only in exceptional circumstances. Before we move ahead, do not forget that section 79 subsection 1 is trying to tell us how the warrant is to be executed to a jurisdiction which is beyond their local control or local jurisdiction, beyond the local jurisdiction. Eleventh point of warrant of arrest. The procedure on arrest of person against whom warrant issued as per the provision of section 80 of Criminal Procedure Code 1973. Section 80 tells us when a warrant of arrest is executed outside the jurisdiction in which it was issued, the person arrested shall, unless the court which issued the warrant is within 30 kilometers of the place of the arrest or is nearer to the executive magistrate or district superintendent of police or commissioner of police within the local limits of whose jurisdiction the arrest was made, or unless security is taken under section 71. Security is taken under section 71 means you don't need to arrest him. Such arrested person should be taken before a magistrate or a district superintendent or commissioner of police. The thing to understand under section 80 is that if a person is arrested in the jurisdiction of others court and it is within 30 kilometers, then that person should be brought before the court that has issued the warrant of his arrest. Section 81. Subsection 1 of section 81 says this thing: the executive magistrate or the DSP or commissioner of police shall, if the person arrested appears to be the person intended by the court which issued the warrant, direct his removal in custody to such court, provided. Now, provided means subject to the condition. Subject to conditions what is given above. Now, provided that if the offense is bailable and such person is ready and willing to give bail to the satisfaction of such magistrate, DSP or commissioner, or a direction has been endorsed under section 71 on the warrant and such person is ready and willing to give the security required by such direction, the magistrate, DSP or commissioner shall take bail or security as the case may be and forward the bond to the court which issued the warrant. Till now we have been studying about warrant of arrest, how it is issued, how it is to be implemented, who can serve it, and how it should be served upon a person to be arrested, and also where a person is residing outside the jurisdiction, what the procedure are going to be adopted. But now in this last point, section 81 speaks about the procedure to be adopted by a magistrate before whom such person arrested is brought. So when a person who has been arrested, he will be brought before the court and will be sent to custody. Definitely, because he has been arrested. Provided, now the condition is that if the offense under which a person is arrested is a bailable offense, and the person is ready and willing to give the sureties and bail sureties, then the person will be released on such sureties as given under section 71. I hope this last point is also clear, and we are wrapping up warrant of arrest with this. Before we end, we need to cover this also, that another condition to section 81 is that if a offense is non-bailable one, it shall be lawful for the chief judicial magistrate or session judge of the district in which the person has been arrested, on consideration of the information and documents referred under section subsection 2 of section 78, to release such person on bail. Now, subsection 2 of section 78 says this thing, that it is the discretion of the court whether to give or not to give a bail to a person who has committed an offense of non-bailable one. Next is subsection 2 of section 81. It says that nothing in this section shall be deemed to prevent a police officer from taking security under section 71, which means definitely a police officer always have the power to take the securities and not to arrest a person as per the provision given under the section 71 of criminal procedure code. So we have repeated this a number of times, that section 71 speaks about security, that a police officer can take security in lieu of arresting a person. And slowly and slowly, you will be remembering all these sections by heart. Replay it, play it again, and unknowingly, you will be remembering all the sections. You will even not realize that you know all the sections. Now we come to the third part of chapter 6, process to compel appearances, proclamation and attachment under the provisions of section 82 to section 86. Only 5 points are there, so let's just do it. First point, proclamation for person absconding as per the provision of section 82. Subsection 1 of section 82 says this thing: if any court has a reason to believe, whether after taking evidence or not, that any person against whom a warrant has been issued by it and has absconded or is concealing himself so that such warrant cannot be executed, such court may publish a written proclamation requiring him to appear at a specified place and at a specified time, not less than 30 days from the date of publishing such proclamation. Without offending anyone, I'm just giving an example so that students can understand this point. Do you remember Mr. Vijay Malia? He has been asked to appear before the court, but he is putting up at England. And definitely, what are you going to do? You are going to publish in the newspaper regarding his being a PO, declaring him PO, and law students knows this thing, that it is going to be done under section 82 subsection 1. Next is subsection 2 of section 82. The proclamation shall be published as follows. Subsection 2 of section 82, clause 1, clause A of clause 1 says, it shall be publicly read in some conspicuous place. Conspicuous, I have already explained the meaning. You should remember it by now. A place which is clearly visible. A place of the town or village in which such person Second point, attachment of property of person absconding as per the provision of section 83 of Criminal Procedure Code 1973. Subsection 1 of section 83 says that the court issuing proclamation under section 82 may, for reasons to be recorded in writing at any time after the issue of the proclamation, order the attachment of the property, may be movable or immovable or both, belonging to the proclaimed person, provided means subject to condition, that where at the time of the issue of the proclamation the court is satisfied by affidavit or otherwise that the person in relation to whom the proclamation is to be issued is about to dispose of whole or any of his property, or is about to remove the whole or any part of property from the local jurisdiction of the court, it may order the attachment simultaneously with the issue of proclamation. So, section 83 is trying to explain that the court is like issuing proclamation orders under section 82, and if it has the reason to believe that the person might, to protect himself or his property, he might sell the property. So, section 83 says that the court has the power to not only declare a proclamation but also attach the property simultaneously so that he is not able to sell his property in part or whole. Next, subsection 2 of section 83 gives the power to the court that attachment of property of the person can be done whether it is within the district or outside the limits of the district magistrate. Subsection 3 of section 83 speaks about the property to be attached is under debt or is a movable property. The attachment under this section shall be made by seizure, means by taking physical possession. Number 2, by appointment of a receiver. Number 3, by order in writing prohibiting the delivery of such property to the proclaimed person or to any one on his behalf. Therefore, by all or any two of such method as the court thinks fit. Subsection 5 of section 83 says this thing, that if the property ordered to be attached consists of livestock or is of perishable nature, what the court is going to do then? The court may think fit it expedient, order immediate sale thereof, and in such cases the proceed of the sale shall abide the order of the court. Next is subsection 6 of section 83, the power, duties, and liabilities of a receiver which is appointed under 6th section shall be the same as that receiver appointed under the Civil Procedure Code 1908. Third point, claims and objections to attachment as per the provisions of section 84. Subsection 1 of section 84 says if any claim is preferred to or objections made to the attachment of any property attached under section 83 within 6 months from the date of such attachment, any person other than the proclaimed person on the grounds that the claimant or objector has an interest in such property and that such interest is not liable to be attached under section 83, the claim or objection shall be inquired into and may be allowed or disallowed in whole or in part by the court, provided, subject to condition, that any claim preferred or objection made within the period allowed by this subsection may, in the event of the death of the claimant or objector, be continued by his legal representative. Section 84 is explaining us that where a property is attached under section 83, within 6 months, any person can claim that the property attached of a proclaimed person does not belong to him or he has a share into it, and whatever the reasons he has, he can claim within 6 months, and the court may, on the discretion, allow or disallow the property to be attached or not to be attached. It also explains us that where a property is attached of a proclaimed person and the proclaimed person dies, in this event, after the death of a proclaimed person, the property will continue to be attached to the court and be continued by his or her legal representative. The same with the claimant or the objector under section 84. Subsection 2 of section 84 says that claim or objections made under subsection 1 may be preferred or made in the court by which the order of attachment is issued, or if claims or objections is in respect of property attached under any order which are made under subsection 2 of section 83 in the court of chief judicial magistrate of the district in which the attachment is made. So basically it is informing us that where a person has to make a claim, he has to make a claim in the court, where in that court which has ordered such attachment, or in the chief judicial magistrate's court of that district. Next is subsection 3 of section 84. It says that every such claim or objections shall be inquired into by the court in which it is preferred or made. So here we have an answer if a question comes in judicial examination that claims and objections to attachment to property is done in subsection 1 of section 84, and the court can inquiry into such claims under subsection 3 of section 84 of Criminal Procedure Code 1973. Next is subsection 4 of section 84. It says any person whose claim or objection has been disallowed in whole or in part by an order under subsection 1 may, within a period of 1 year from the date of such order, institute a suit to establish the right which he claims in respect of the property in dispute, but subject to the result of such suit, if any, the order shall be conclusive. Subsection 4 of 84 is trying to tell us that if the claim of your client has been disallowed, they can institute a suit to establish their right, their claim in the respective property which is in dispute or which has been attached by the court, but it shall be subject to the outcome of the case. Fourth point, release, sale, restoration of attached property and as per the provision of section 85. Subsection 1 of section 85 says if the proclaimed person appears within the specified times in the proclamation, the court shall make an order releasing the property from the attachment. Now the subsection 2 of section 85 says that if the proclaimed person does not appear within the specified time in the proclamation, the property under the attachment shall be at the disposal of the state government, but it shall not be sold until the expiration of 6 months from the date of attachment and until any claim, prefer or objection made under section 84 has been disposed of, unless it is subject to speedy and natural decay, or the court consider it that the sale would be for the benefit of the owner. In either of the cases, the court may cause it to be sold whenever it thinks fit. So section 85 tell us two important points. First, that if the proclaimed person appears within the specified time, the court shall make an order to release the property from the attachment. And the second one is that the court can order state government to sell the attached property after the expiry of 6 months from the date of attachment. And this condition to sell the attached property after the expiry of 6 months is also waived off if the property attached is of perishable nature or the court considers that the sale would benefit the owner. In either of the cases, the court may cause it to be sold. So, if a question is asked whether the court has the right to sell the property, yes, it has the right to sell the property attached in the proclamation under the provision of section 85, subsection 2. And that is in case when the proclaimed person does not appear within the specified time in the court. Next is subsection 3 of section 85. It says that if within 2 years from the date of the attachment, any person whose property is or has been at the disposal of the state government under the subsection 2 of section 85, which we have already covered right now, appears voluntarily or is apprehended and brought before the court by whose order the property was attached, or the court to which such court is subordinate, and proves to the satisfaction of such court that he did not abscond or conceal himself for the purpose of avoiding the execution of the warrant of arrest, and that he had not such notice of the proclamation as to enable him to attend within the time specified therein such property, or if the same has been sold, the net proceeds of the sale, or if part only thereof has been sold, the net proceeds of the sale and the residue of the property shall, after satisfying therefrom all costs incurred in consequences of the attachment, be delivered to him. Now let's try to understand what subsection 3 of 85 is trying to tell us. It says that the property has been attached, right? It has been attached of a proclaimed person. The state government can sell it, and within 2 years, if the person proclaimed appears before the court. Now, definitely, he's going to appear before the court so that he can save his property. So, he can save his property. This is what subsection 3 of section 85 says that. And in case the state government has already sold his property, then also he can get the profits and benefits that the government has earned from selling that property. So, a person is not at a total loss in case he satisfies the court that he was not avoiding the warrant of arrest. Got it? Okay. Now let's proceed to the next one. Now we come to the last point, fifth point of PON attachment, that is appeal from order rejecting application for a restoration of attached property as per the provisions under section 86 of the Criminal Procedure Code 1973. It says that any person referred thereunto in subsection 3 of section 85 who is aggrieved by any refusal to deliver the property or the proceeds of the sale thereof may appeal to the court to which appeals ordinarily lie from the sentence of the first mentioned court. So, section 86 basically deals with appeals, where a property of a proclaimed person is attached and such property is sold, or it is attached, or it has been sold, and the court has refused to give the possession of the property or the profit from the sale. In those cases, a person can appeal as per the provisions of section 86 if that person feels that he has been wrongly rejected by the court. Now we come to the fourth and the last part of the chapter 6, process to compel appearances, and that is other rules regarding processes as per the provisions under section 87 to 90 of Criminal Procedure Code 1973. Part 4, having 4 points, And the first point is issue of warrant in lieu of or in addition to summons as per the provision of section 87. Even before reading the Bear Act language, it is well understood that section 87 is trying to tell us that the court, um, if he wants a person or compel a person to appear before a court, while issuing a warrant, can issue summons instead of issuing a warrant, number one, and to compel an appearance of a person while issuing a warrant can issue a summon of arrest as well in addition to warrants. So both the things can be issued, and this is given under section 87. So even before going into the language of the Bear Act, I think you have understood this point. Still, let's cover the Bear Act language, what it says. A court may, in any case in which it is empowered by this court to issue summons for the appearances of any person, issue, after recording its reason in writing, a warrant for his arrest. Clause A of Section 87 says, if either before the issue of such summons or after the issue of the same but before the time fixed for appearances, the court sees reason to believe that he has absconded or will not obey the summons, or Clause B of Section 87 says if at such time he fails to appear and the summon is proved to have been duly served in time to admit of his appearing in accordance therewith, and no reasonable excuse is offered for such failure. Second point of other rules regarding processes is power to take bond for appearances as per the provision of section 88. Section 88 says that when any person for whose appearances or arrest the officer presiding in any court is empowered to issue a summons or warrant is present in such court, such officer may require such person to execute a bond with or without sureties for his appearances in such court or any other court to which the case may be transferred for trial. Now let's understand in easy language what section 88 is trying to tell us. Section 88 informs us that where a person is required by the court to appear in the court, either by the issue of summon or by issue of his arrest warrants, it is to be issued by the presiding officer of the court or the officer which is present in the court. And the second and the most important point in section 88 is that such a person may require to execute a bond with or without sureties for his appearances in such court. And the third thing, it also says it is also applicable in cases where the courts of other jurisdiction has issued such warrants. Arrest on breach of bond for appearances as per the provision of section 89. Now section 89 says this thing: when any person who is bound by any bond taken under this code to appear before a court does not appear, the officer presiding in such court may issue a warrant directing that such person be arrested and produced before him. Now, this is very interesting that under section 88, a person to avoid arrest, what he does, he gives bonds that he will appear, that I'm assuring that I will appear in the court on a given date, but he does not keep his promise. Even after giving the bonds, he does not appear to the court. In that cases, section 89 gives the power to the court where a person has given a bond, but even after giving a bond does not appear, may be arrested. A court will issue a warrant for his arrest, and that is to be issued by the presiding officer of the court. Now we come to the fourth point of the fourth part of the chapter 6. Other rules regarding processes. Point number 4. Provisions of this chapter generally applicable to summonses and warrants of arrest is given under the provision of section 90. Now, section 90 is a general provision. It does not inform the processes of compelling the person to appear, but it informs us that the provision contained in this chapter regarding or relating to summon and arrest of warrant and their issue, service, and execution shall, so far as may be, apply to every summons and every warrant of arrest issued under this code. It is just informing, it is just giving an information to us that under this code, where any service of warrant or summon is to be done, it is to be done only as per the provisions given under this chapter. With Hello, guys, do not stop. Let's do some revision first. Chapter 6, Compel to process appearances. How to compel the person? First, summons. Second, warrant of arrest. Third, proclamation and attachment. Fourth, other rules regarding processes. Simply weird person out. Sections: summons starts with 61 and ends with 69. Warrant of arrest starts with 70 and ends with 81. Proclamation and attachment starts with 82 and ends with 86, and other rules regarding processes starts with section 87 and ends with 90. Now let's revise the summons. First part 61, the forms of summon and how it to be served, section 62. To be served on corporate and societies, section 63. Corporate people or societies, when required, they are not available. So service of summons when person cannot be found, next 64. When service cannot be effected as before, section 65. Then comes the government summons, section 66. Government summons is always outside the local limits of his office. Next is section 67. Even the serving officer is a government person, so even he is not available to proof of service in such cases when serving officer is not present. That is section 68. When your topic of summon has been covered, you need to have a witness about that. So service of summon on witnesses by post is the last one, which is section 69. And I'm sorry, please, government employees or other persons, don't be offended. This is just a jingle. Tricks to learn the topic section wise. Now let's revise warrant of arrest from section 72, section 81 of Cr.PC 1973. First one again begins with the forms of warrant of arrest and it shows the duration, which is under section 70. It has the power to direct security to be taken under section 71. Warrants to whom directed is given in the section 72. Warrants directed to any person, 73. Warrants directed to police officers, 74. If you have to give a notification of substance of warrant under section 75, says the thing, it can be done. And if the warrant of arrest has been successfully done, then what is to be done? The person arrested to be brought before the court without any delay under section 76. Next three sections, it talks about the execution of warrant of arrest. Where warrant may be executed, where warrant to be executed outside the local jurisdiction, warrant directed to police officer for execution outside jurisdiction. All is covered under section 77, 78 and 79. All talking about execution. Now, if they are talking about the execution, procedure on arrest of person on whom warrant is issued, that is given under section 80. Now you see that warrant of arrest has come to an end, compelling a person to appear before the court, and the last one says the same thing. Procedure by magistrate before whom such person arrested is brought, that is section 81. Here we ends with the topic warrants of arrest with some teeny weeny tricks to remember. Third one, C part, proclamation and attachment. Whenever you come to this part, always remember this trick that a person who is in love consider other as their own property. love is not for sale, and others having objections must appeal. Did you like this trick? No? No problem. Let's proceed. Proclamation for a person absconding, section 82. A person who's absconded must be having a property, attach his property, attachment of property of a person absconding under section 83. If a person's property is attached, he or other person may claim or object. That is given in the next section, claims and objections of attachment of property under section 84. When a court attaches the property, or when a claim has been rejected or accepted, or whatever the case may be, the attached property can be sale, resale, and restore. Section 85 says about such things. And in the end comes the appeal from order rejecting an application for restoration of attached property under section 86, attached property which the court has ordered for. With this, we come to the fourth and the last part of this chapter, other rules regarding processes, as given under section 87 to 90 of Criminal Procedure Code 1970. Before I start this topic, let me remind you once again, this chapter is made to compel a person appear before a court through summons, warrants, proclaiming him as an proclaimed offender, or attaching his property. And they all are given under section 61 to section 86. The other procedures or other rules, they are: 1. Issue of warrant in lieu of or in addition to summons. That's given under section 87. Powers to take bond and arrest a person on breach of such bond, they are given under section 88 and 89. And in the end, the section 90 says this thing, that all these provisions of the chapters are applicable to summons and warrants of arrest.